Thank you, Your Honor. The primary election is imminent, and granting plaintiff's preliminary injunction would threaten the orderly administration of that election, which is only days away. The plaintiff has made clear that he wants to prohibit the use of ballot counting devices across the state and has pursued a number of different avenues to do so. And he required hand counting of every ballot by the moderators he just indicated. He additionally claims that ballot counting devices, which have been in use for decades, pose a safety risk. That's based on speculation. That's based on a misreading, misapplication of standards that he cites in their application to particular devices, and it's not based in evidence or any occurrence of injury or risk from the operation of ballot counting devices. Plaintiff's claims are unfounded and they're speculative. He can't meet the burden that he bears for granting of a preliminary injunction. And I think the testimony today supports the proposition that ballot counting devices have been in use regularly in every election for decades in New Hampshire. They have done so consistent with the Constitution. They have been in operation consistent with New Hampshire law. They are consistent with certification by the Ballot Law Commission. All of that indicates that the preliminary injunction should not be granted in this case and would be improper to do so. I'd just like to touch on the operation of ballot counting devices. I indicated in use for decades. My understanding is that from the mid-90s, that is when the AccuVote ballot counting device, which is the model that is approved by the Ballot Law Commission, has been utilized. They're used in approximately 200 polling locations across the state and handle roughly 3/4 of all ballots cast in the state. I believe that in the 2020 primaries, that there were 147,000 votes cast in Republican primaries and approximately 155,000 votes cast in the Democratic primaries. That's more than 300,000 votes that were cast in the 2020 primary election. We're talking about a very large number of votes, and the majority of which are counted by ballot counting devices. As the plaintiff alluded to, adoption and use of ballot counting devices is proper based on RSA 656:40. The approval by the Ballot Law Commission is under 656:41, and then consistent with 656:42 are the testing procedures and protocols that verify the outcomes and the voting, the ability of ballot counting devices to accurately count votes in advance of an election. So just highlighting there that the certification applies to the class of ballot law, ballot counting devices in the state, the AccuVote machines, one type of machine. Every one of those machines is certified by that determination of the Ballot Law Commission. Additionally, before each and every election officials in every town and city, town and ward, must conduct a test of that machine, of any machine that they intend to use in that election. That means breaking the seals on the machine in both the container and relating to the memory card, and then testing that machine against a series of test ballots that are being counted to determine and confirm that the ballot counting device accurately counts those test ballots. That is an outcome-based test that assesses the ability of that machine in that particular election at that time to operate in that election. If the ballot counting device does not accurately count those machines, then it's not put into use in that election. And that's all consistent with New Hampshire law and the testing protocols established for the handling of these ballot counting devices that have been used for decades. I'd also point out to the court that there's an additional verification of outcomes of the use of machines that relates to the recount procedures committed under law as well. There's some testimony as to recounts in them. In one circumstance, recounts routinely confirm that ballot counting devices accurately identify election winners. That is something that is very clear from the record of recounts in the state of New Hampshire. I'd also just like to touch on the history as presented by the plaintiff here and identifying that he filed a remonstrance or remonstrances that had no legal effect, that he petitioned the Supreme Court, that petition was denied, that there have been ballot measures introduced in a number of towns across the state relating to the use of ballot counting devices as an exercise under the law of determining whether would utilize a ballot counting device or would hand count, where the people of the town vote on how they want their votes counted. Not a single one of those ballot measures passed in this past town election season, Your Honor. The plaintiff is seeking different venues for his ultimate goal of trying to prohibit the use of ballot counting devices. So today we're hearing a focus on safety of ballot counting devices that then goes to speculation, that goes to possibilities that have not been realized in the history of use of ballot counting devices in New Hampshire in every election. Moving to some of the legal questions before you and what is required for granting a preliminary injunction. New Hampshire case law makes clear that a preliminary injunction is an extraordinary remedy and that it should be issued as only a preliminary measure to preserve the status quo. Prohibiting the use of ballot counting devices is not preserving the status quo. That would be a severe disruption of the status quo as the plaintiff seeks to do. And it is the plaintiff's burden to establish the granting of the preliminary injunction. The plaintiff must show that he's likely to succeed on merits, that there is the immediate danger and irreparable harm if a preliminary injunction is not granted, and that there's no adequate remedy at all. Additionally, I would note that in this case, the plaintiff is seeking essentially, functionally, an outcome on the merits, a final outcome on the merits, the use of ballot counting devices in New Hampshire elections. He is seeking that as part of a preliminary injunction. That raises the standard of analysis because he is seeking a final outcome, a final opinion in the form of a preliminary injunction filed days before this hearing with expert testimony presented to this or presented to this court only a couple of days before this hearing. That's an improper use of a preliminary injunction, putting aside that he does not meet the legal standard required to succeed on a preliminary injunction. On the likelihood of succeeding on merits, the plaintiff cites the Constitution. He cited Article 32 in relation to his argument about the moderator conducting the counting of votes. Your Honor, he misstates the constitutional language. The plain language of the Constitution does not require hand counting. It does not require that one individual count votes, or even three individuals, as likely identifies, count the votes in an election. He misstates in his request for a preliminary injunction the status of an election. It is a public meeting. It is conducted in the open. It is conducted in public and must be. That's one of the reasons why counting has to occur on election day, is because the votes are collected, the votes are cast, the votes are counted, be it by hand counting or by a ballot counting device on election day. His interpretation and using his description of it, of saying either three people or one people can count votes, would render impractical any election in New Hampshire. To have one individual count the votes in a jurisdiction as large as our largest town, some 10, 15, 16,000 votes. That's not possible. The remedies we see presentation under a veneer of constitutional interpretation is not practical, and it's not consistent with longstanding practice, historical practice in elections in New Hampshire. There is no prohibition in the Constitution or statute on the use of ballot counting devices. They are authorized under New Hampshire law. Jurisdictions use ballot counting devices on the basis of that authorization and have done for decades. The plaintiff also cites to a number of political sources with propositions that ballot counting devices are unsafe. Just note there that a number of the safety standards that it identifies or electric utilization systems, such as those installations that power lights for employee workspaces, maintenance requirements related to other public lighting systems or workplace lighting systems, electrical systems. Those don't apply. He cites a number of non-binding voluntary commitments, that a number of them are non-binding and voluntary, and insist that they apply and would preclude the use of ballot counting devices in New Hampshire. That's a misstatement of the legal obligations relating to the use of ballot counting devices, and is contrary to the evidence regarding the safety of ballot counting devices and the inability to identify any circumstance where a ballot counting device posed a risk.
Examples. Yeah.
I'd also just briefly touch on standing, Your Honor. It's slightly unclear that the text or the descriptions that the plaintiff uses make it unclear as to whether he's referring to the ultimate objective of prohibiting the use of ballot counting devices across the state, whether the preliminary injunction would apply across the state, or whether he's just referring to Auburn. To that end, Your Honor, we would assert that he does not have standing to contest the use of ballot counting devices across the state. That would be, if he does have standing, limited to Auburn alone. We just move that his request relating to the preliminary injunction does vary. It's not clear whether he is requesting a prohibition statewide or merely Auburn, since it varies depending on the paragraph. He's also made no showing as to irreparable harm in the absence of a preliminary injunction. Then that would be a threshold that the plaintiff must establish in order for the granting of the preliminary injunction to be proper. These ballot counting devices have been used again for decades, dozens, hundreds of elections. They've been used routinely according to New Hampshire law, and there is no prohibition on the counting of the plaintiff's votes as he asserts. He has at least three options for how his ballot may be counted. It can be through casting his ballot in the ballot counting device. It can be by writing in names on the ballot, write-in ballots, write-in votes are counted by hand, or pursuant to the discretion and powers of the moderator by casting a ballot in the side department or other ballot collection box to be counted by hand. So there are opportunities for the plaintiff to exercise his right to vote and cast a ballot. It appears from his prior action that he chose not to do that in the past and would choose not to do that again, but that opportunity is presented to him both under New Hampshire law and election practice. Your Honor, just touching on this, since the plaintiff is insisting that this is about safety and public safety, he cites that political authorities relating to that can identify any particular risk posed by ballot counting devices. It's speculative. The evidence that he presented would refer to the modems, the wires, and modems and serial ports in the back of a ballot counting device being disabled or cut pursuant to an order by the Ballot Law Commission in 2010. The devices have been operating in that state since the issuance of that order. It hasn't identified any safety occurrences. related to the disabling of those modems or serial ports. I'd also bring your attention back to the testimony of Mr. Iring. My final question to him was whether in the course of the Lumen audit, when the ballot counting devices from Lumen were being handled extensively, used, analyzed, pieces of them taken apart to be assessed, that at no point did any of those devices explode. He called it a ridiculous question. Your Honor, that's because he understands the premise here and the evidence that there is no evidence supporting a safety risk for the ballot counting devices that have been in routine use in elections across New Hampshire for decades. It is that proposition and claim is ridiculous. Your Honor, I'd finally turn to the principle of judicial non-intervention as essential in this circumstance. It's commonly referred to as the Purcell principle. That would be where federal courts decline to intervene in elections in the weeks or months leading up to an election. That has been adopted by various cases or in different forms by courts across the country, including the New Hampshire Supreme Court. Essentially, that principle is that courts should not be intervening in the final months, weeks, or days before an election in a way that would sow confusion or create chaos in the actual administration of elections. Courts' understanding of a remedy can inflict great damage, or the changing of law, the changing of status, the changing of practice and procedure can inflict great damage on the exercise of democracy in the form of having our citizens vote. That applies months out from an election, weeks out from an election, or days before an election. The plaintiff is seeking to prohibit jurisdictions from utilizing devices to count ballots that have been used for decades. This court should not intervene and inflict that harm on New Hampshire's elections. The plaintiff has not met the legal burdens that he bears to address or for a preliminary injunction to be granted. And beyond not meeting those legal burdens, the principle of judicial non-intervention is essential in this circumstance. The changing of the procedure from using a ballot counting device to hand counting, the plaintiff asserts there is no harm there, that it is not difficult and that it's routine. Going back to the dimension of more than 300,000 votes in a primary election in 2020, the time and the resources and the volunteer effort it would take to count those votes in the 75% of ballots cast that instead of going to a ballot counting device would have to be hand counted would sow chaos in our elections. Election officials have not been able to do this. They are not structured, not been able to recruit the personnel required to extend the public meeting from hours past when the polls close to through the night or into the next day or subsequent days in order to hand count those ballots. Because not only would we be talking about hundreds of thousands of ballots, but each ballot may contain a dozen or more races, some with additional...
Maybe I misread his motion, but he specifically said it would be about 500 ballots in the town of Auburn. I read his motion as just specifically applying to the ballots in Auburn, based on the fact that he was saying there would be no harm to the town because it's 500 votes. Or at least that's what it was 2 years ago or in prior elections or whatever. It was a very small number.
And Your Honor, on information received, I believe that number is much too low. I believe that there may be further testimony as to that and the impact on the town.
Okay.
But that is the ultimate objective of prohibiting the use of ballot counting devices here would disrupt election operations, would disrupt the ability of election officials in the final days before an election to administer an orderly election. Because of that, Your Honor, the state is asking you to deny the plaintiff's motion for a preliminary injunction. It is not proper. It has not met the legal thresholds. Factually, this state's circumstances misunderstands the law. It's not appropriate at this late stage to make this change with an extraordinary measure that is not appropriate in the circumstances. Thank you for having me.
Croc TV.